Welcome to the Employment Law Channel. I'm Scott Drake. Today we're discussing an article written in The Atlantic by my guest, Kathleen Peratis. She practices law with the employment law firm of Outten and Golden in New York. The article is titled, "Why So Many Victims of Sexual Harassment Stay Silent Still." Kathleen, welcome back.
Thank you very much.
So Kathleen, in your article you use Anita Hill and Clarence Thomas as an example and the hearings back from 1991. Talk about how things have changed. The law has perhaps become more clear, but still it is difficult to pursue this type of litigation, and many people who are victims still remain silent.
Well, there are a lot of reasons. I think one of the reasons that a victim might not pursue a remedy as far as she can, which means starting a lawsuit and processing a lawsuit, is that for many kinds of jobs, it will kind of make you a marked woman. It will make future employers not so eager to hire you, even though that's illegal, because employers worry about anybody who has a penchant for suing them. So that kind of bad reputation is a very strong reason that women didn't bring lawsuits then and sometimes don't bring them now. And there are other reasons. It's extremely difficult to be a plaintiff in these kinds of cases. It can be empowering, but it can also be very painful. So the empowering aspect, the possibility of getting money aspect, has to be balanced against the painfulness of the lawsuit itself.
Since then, would it be safe to say that the laws are more clearly defined here? Because I mean, I would guess that if someone, in my experience too, in the corporate world, you cannot really have a position in a corporate environment or a company environment without having to go through a sexual harassment, class, and to talk about exactly what it is and why, you have to be extra careful. Yet this still seems to be a really, really big problem.
Well, I think it's less of a problem now, especially in big companies, than it used to be. And it's not as much a matter of the clarity of the law, although that's part of it. But it's more a matter of the unacceptability of the conduct. I think the conduct itself is much less socially acceptable than it used to be. But I must say, I had a client in this morning who was telling me a story of what happened to her, and the bad actor, as we call him, did one of the things he did to her the very day that he had sexual harassment training. As soon as the training was over with, he said, Jill, I'll change the name, this doesn't apply to us. And she was thinking, are you out of your mind? So the sexual harassment training definitely has helped, but it's not a 100% deterrent.
Let's talk about these days, again, as you say, the law is somewhat clearly defined. What exactly, is legal, as you talk about in your article? And there's really two types here. There's harassment, and then there's a hostile environment. And can you talk about those?
Yeah, sometimes they're both. Generally, we say it's a hostile environment when there's an environment that is suffused with sexism, with gender jokes, with threats, and just a really bad atmosphere, making women feel fearful or marginalized. And sexual harassment generally applies when you yourself have been a very specified and particular victim, like it's your boss who's hitting on you, like it's you who's being touched or you who's being threatened. So, and for many people, both exist at the same time.
And we're talking about conduct that is inherently unwelcome. And how does one convey that? Obviously, a person may say, I really don't feel comfortable with you talking like that, please stop. Or sometimes they'll just be offended and not say anything. How does that affect things?
Well, I think if you don't say anything, you have a problem that the bad actor didn't know that what he was doing, and sometimes what she was doing, was offensive. Sometimes it's so clearly offensive that you shouldn't have to complain in order for the actor to know that it wasn't welcome. But many people, as you know, don't complain because they're actually fearful of losing their job or losing their position. So it really does put the victim in a very difficult position, because when they worry about losing their job, they're right to worry, because you do put yourself at risk. Some companies are extremely responsive. They'll fix it right away, even get rid of the bad actor. But in some companies, it doesn't go that way. So there's always a little element of risk.
And I'm sure that some people try to maybe talk to human resources and say, listen, I'm having this problem. I don't know really how to handle it, but I don't want to make it a big deal. And sometimes that can blow up as well.
Well, often the victim will say, I'm telling you this, but I don't want you to do anything about it. I don't want the person I'm complaining about to know, and I'm just sort of going on record, but I don't want you to do anything. That really puts the HR person in a position, I mean, they sometimes think it means they shouldn't do anything, but it really doesn't mean that. The HR person should always do something, even if they've been told that they want it to be kept confidential. When you go to HR, you can't really expect that it's going to go no further. You should expect that it will.
And there are, in the event that someone does, for example, as you use as an example, make a complaint, end up losing their job over it, there is sufficient remedies, legal remedies to offer restitution for things like that these days?
Well, actually, that's called retaliation, what you just described, having something bad happen to you because you've made a complaint, and as we call it, you've engaged in protected activity. Sometimes the complaint itself, the conduct that you're originally complaining about, it's maybe close whether it's legal or not legal, but retaliation is really illegal. We often see cases where the discrimination is a little questionable, but the retaliation is very clear. So an employer, by retaliating, can take a medium case or even a bad case and make it into a good one from our point of view by engaging in retaliation. That's very serious and often much easier to prove.
Finally, in the last few seconds here, you use Anita Hill as an example, and you talk about the hearings that she went through, and even though that things have changed today, you think, even though a lot of the evidence was, very well substantiated, that she still would have difficulty with a legal claim here?
Not today. She would have had difficulty with a legal claim at the time because courts were still not exactly clear, and they're much clearer now, about what's personal and what's professional, about how much it takes to constitute a claim. As far as we know, as far as Professor Hill ever said, there was never any touching. It was a very unpleasant, hostile environment. I think that claim, given what I believe happened and what Professor Hill claimed, I think that would probably be a good legal claim today. I'm not so sure it would have been acknowledged as a good claim 20 years ago.
Because as you say, even though the law sometimes is clearly defined here, that the judiciary sometimes tend to ignore that in some
Well, you
cases,
see
or
what
have
happened to her in the Judiciary Committee. The senators on the Judiciary Committee just tore her apart. It was really quite shocking what happened to her.
All right, my guest has been Kathleen Peratis. She practices law with the employment law firm of Outten and Golden in New York. Kathleen, again, thank you so much.
Thank you.